Good morning. Welcome to the 294th District Report. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Kyle Holland. Here. Gary McKeever. Here. Chase Harrison. James Arnold. Here. Billy Autry. Billy Ray Autry. Here. Jody Denton. Here. Miranda Hatton. Shane McCall. Linda McFerrin. Jarek Munns. Eddie Pate. Here. Gina Prox. I believe Ms. Prox is going to be appearing via Zoom this morning. Is that correct?
Yes, Judge. I just got an email from her. She said that she tried to sign in, saying to fill out the document. You see her in the meeting?
I do not. Junior Spence. Martin White. Here. Vincent Offord, CR 25101. I believe Ms. Conan is appearing via Zoom today, and I think we'll have to have an announcement on Mr. Offord. I believe that she's going to announce that he is in the hospital or something of that nature, so we'll recall that case. Jace Quaid. James Fontenot. Gilberto Jimenez. Richard Strange. Jeremy Treadway.
Across the hall.
Thank you. All right, is there anyone in the courtroom, your name's not been called, you expect to be on the docket? All right. Do we have any counsel that's ready?
Yes, Judge. I'm Gary Raven.
Receiver, if you'll come forward, please. All right, this is cause number CR 25-00081, State versus Gary Ray Van McKeever. We're set for docket call. Any announcements?
Your Honor, we're in the process of negotiating maybe a resolution if we can. I'm not saying that we can or at this point, but we've begun that just recently. So if we could get one more docket call on this, we'd appreciate it.
State.
No objection, Your Honor. I did advise counsel of the court's policy on setting it to the trial docket, and that we were in early stages of negotiations. For that reason, the state would join in that request.
Okay. Court will grant Mr. McKeever one final docket call. That would be on December 4th at 9 a.m. Do you have any scheduling conflicts, Mr. Breton?
No, Your Honor.
Okay. That'll be a final docket call. So that day I'll expect to hear either there's a plea agreement or we'll be setting it for trial.
All right, may you excuse?
Yes, thank you, Mr. Breton. Thank you. Good to see you. Good to see you. Ma'am, remind me your name.
It's Mackenzie Zarate, Judge.
Right.
I'm here for Chase Harrison.
Okay. Mr. Harrison. This is cause number CR 25131, State versus Chase Allen Harrison, and we are set for pretrial today. Go ahead.
Yes, Your Honor, we are requesting another pretrial date. I was just given a USB drive with some additional discovery from the state, and it's my understanding that we are waiting on 2 more videos to be made available in a playable form.
State.
Yes, Your Honor. So this is a case that was investigated twice, originally in 2019, and we've been working on getting those videos formatted in a way that can actually be viewed by defense. I learned yesterday that what we had uploaded was not in a format that could be viewed, so I copied those onto a USB and delivered them today. However, we still have a forensic interview that needs to be formatted properly and that uploaded. So we would request a little bit more time so we can figure out a way that we can make that viewable for defense.
All right, we're available on December 4th.
I believe so, Your Honor, yes.
All right, court sets Mr. Harrison for pretrial December 4th at 9 a.m. Once he signs and gets his form, he's free to go.
Thank you, Your Honor.
You're welcome. Mr. Manning, I do see Ms. Fox in the waiting room now. Wait, you ready? Are you ready on?
Or Mr. Arnold?
Mr. Arnold. State of Texas versus James Douglas Arnold, CR 25-117. Mr. Arnold, come on up. Mr. Arnold, set for pretrial, go ahead.
Yes, Judge. Mr. Arnold is set for pretrial. I have not found any contested issues to be raised. However, Mr. Arnold is coming to my office on Monday. Would ask if we move to docket call that we reserve the right to file any motions in a timely fashion if those are discovered through my meeting with Mr. Arnold. We would request to be set on the docket call, moving this case forward.
State.
No objection, Your Honor.
All right, court sets Mr. Arnold for docket call December 4th. Mr. Manning, I need to know if Mr. Arnold can make any payments towards his pretrial release fees. I show that he's $360 delinquent.
Were you able to hear the judge?
Oh, no.
Okay. He says that you're delinquent on your release fees that he ordered you to pay for pretrial release. Were you aware of that?
Is that like a probation fee or something there?
It's similar to that, yes.
Yeah,
Okay. Can you make a payment today?
no,
Okay.
no, I'm not going hungry. No, I'm gonna work. I'm fixed income and I'm disabled.
So, Judge, if I may, I'll meet with Mr. Arnold and the pretrial release officer and see what can be done in his case.
Thank you, sir.
Thank you, Judge. Step outside. I'll talk to you outside in just a second. Yeah. You'll step into the hallway. Okay. So wait for me right up there. Here's your reset. Next, ready on Billy Autry.
Billy Ray Autry, CR 25-161. CR 25-161, 162, and 160. Mr. Autry is set for pretrial in all three cases. Go ahead.
Hi, Judge. This is Mr. Autry, and we would request that he be set for docket call on all three cases. We have received an offer recently, and I'll convey that to my client and have him ready for our next sitting.
All right. Court sets Mr. Autry for docket call December 4th, 9 a.m. in each case. Once he signs this form, he's free to go.
Thank you, Judge. Judge, next we have Jody Denton.
Jody Lynn Denton, CR 25-145. Ms. Denton set for pretrial. Go ahead.
Yes, Judge, we'd asked for additional pretrial in this case. Ms. Denton came into my office last week. We discussed the discovery and found that there's things missing. I checked a couple other errors that discovery may be and emailed the state this morning requesting that additional discovery. So we'd ask for additional.
Any objection? State.
No objection, Your Honor.
All right, court grants the request. That's Ms. Denton for pretrial December 4th, 9 a.m. Who's next?
Judge, next I have Ms. Hatton.
Miranda Ann Hatton, CR 25-146.
And Judge, I noticed on the docket that it seems to have
Two.
duplication. And I believe on Ms. Hatton's case, we are still at pretrial, but I was unable to verify that before court.
I'll take your word for it, and we'll make sure that we get this off the docket. I don't know why it's duplicating like that. All right, and that's what I'm preaching on.
Yes, Judge. I have gone over the discovery, however, not had a chance to meet with Ms. Hatton. Request to be set on docket call with the ability to file any pretrial issues if Ms. Hatton comes and bring those to my attention. We also received an offer in this case I need to discuss with her before docket call.
State.
No objection, Your Honor.
All right, court grants the request. That's for docket call December 4th. Court will grant leave to file late pretrial motions for good cause shown.
Thank you, Judge.
Next.
Judge, next we're ready on Mr. Pate.
Eddie Pate, CR 25-83, pretrial. All right, go ahead.
Yes, Judge. As the court may be aware, sorry, at our last setting, we requested the state investigate a pretrial, received no update on that pretrial issue. My client requests to be set on docket call. Judge, I'd ask if, as I said, we believe the pretrial issue may be dispositive, and so I'd ask that if something comes up through the additional investigation by the state, that we be allowed to file any necessary and proper pretrial motions.
Any objections?
Your Honor.
All right, court sets Mr. Pate for docket call December 4th. County court will allow late pretrial motions upon showing of good ones.
Thanks. Right. What do you think I'm over?
Who's next?
Judge, next ready on Mr. Junior Spence.
Mr. Spence. This is cause number CR 25-103, State versus Junior Lee Spence. And Mr. Spence is set for docket.
Yes, Judge. Mr. Spence has, as you can see by the number of settings, been moving this case along. However, I learned recently, I believe it was this week, that the state may have some potential mitigating information to be provided to us regarding some of the witnesses in the case. We request for additional docket calls so we can ferret out what those issues may be and how they would impact the offer and the resolution of this case.
Any objections?
No objection, Your Honor.
All right, court sets Mr. Spence for docket call December 4th at 9 a.m.
Judge, would we like to take up Mrs. Prox's case at this point?
All right, this is. Let's see.
Sorry.
Prox, it's okay. Ms. Prox, can you see and hear me?
Yeah.
Can you see your attorney?
Oh,
Turn your
sorry.
phone.
There we
turn your
go.
phone.
No,
All
I
right.
don't see my attorney.
All right, if you're on your phone, you may have to move left or right.
Okay. Sorry, he hears something outside. He just started acting. Bad boy. I can't do it. How do I get him on here? It
May
just
have to
shows me
move.
you.
Listen,
it
you gotta
doesn't-
listen. You have to swipe left or right on your phone.
Oh, I see. Okay.
All right, Ms. Brox, I'm gonna call your case. This is cause number CR 24-220, State of Texas versus Gina Lynn Prox. We're set for docket call. Mr. Manning, I believe you filed a motion to withdraw. This is also in cause number CR 24-221. Go ahead.
Yes, Judge. Before I begin, this case, Ms. Prox is a co-defendant for a case that was sent in the trial docket, Mr. Ray Williams. Mr. Ray Williams was represented by my law partner, Richard Schmidt, and there was a conflict that was asserted by Mr. Williams regarding the representation of both Ms. Prox and Mr. Williams. Through my conversations and discussions with Ms. Prox, after I filed the motion, she and I can elicit testimony on this. She does not wish for me to withdraw. She wishes for me to remain on her case. However, I explained to her that the assertion of the conflict by Mr. Williams could impact my representation in her case, and because of the situation with the trial, and filing the motion of withdrawal at that point in time, that I felt that it was necessary to address this issue sooner rather than later. And as I said, if you'd like, I can elicit testimony that Ms. Prox does wish to waive her conflict as it regards to her.
Ms. Brox, did you hear everything your attorney said?
Yes, sir.
Okay. If you'll raise your right hand, I'm going to place you under oath and allow you to be questioned on the limited purposes of the motion to withdraw on the issue of conflict. Ms. Brox, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
I'm going to ask you to put your phone down so it can be real still. Quit messing with the dog. Quit doing anything else.
Well,
Pay attention. Listen, no excuses. Just do what I tell you to do. You're in
I'm
court. I'm allowing you to listen. You're not listening. You're preparing to talk. That's what you're doing. Be quiet. Be still. All right. We're in court. I know you're at home, but we're in court. And I've got to move this along efficiently. I can't do it if I see the phone doing this, you messing with your dog, you doing all this stuff. So be still, be quiet. Go ahead, Mr. Manning.
Ms. Prox, I made you aware of the assertion of the conflict by Mr. Ray Williams at the last jury trial setting. Is that correct?
Yes, sir.
And we had previously discussed, when I first began representing you, the potential conflict that may exist between you and your co-defendant and being represented by both me and Mr. Schmidt. Is that correct?
Yes, sir.
And you chose and requested that we go forward, and I continue to be your lawyer at that time. Is that correct?
Yes, sir.
And I explained to you the reasons why I needed to file this motion. And at that point in time, it was still your assertion that you wanted me to remain as your attorney. Is that correct?
Yes.
And you understand that even though you want me to be your attorney, and I would love to still be your attorney, that Mr. Williams may assert a privilege that would break that attorney-client relationship due to his ability as a co-defendant to assert a conflict of interest. You understand that?
Yes.
No further questions this time, Judge.
State.
No questions, Your Honor.
Okay. Any other announcements?
No other announcements, Judge.
All right, so Ms. Prox is withdrawing her motion to withdraw counsel. Is that correct?
Judge, the reason I filed it was because I believe that there is a privilege, or not a privilege, but a argument that exists by Mr. Williams. And so I want to get out in front of it and let the court know that my client is on board with my representation. However, she also understands that at any point in time, Mr. Williams could assert that privilege and there would be a conflict that would have to be addressed.
Okay. All right. Any announcements on docket call?
No, Judge, would ask that continue with,
Jury selection.
continue following with Mr. Williams.
Okay. And I believe, is she already set for jury selection?
No, Judge, we were holding it in lieu.
Okay. All right. Court will set Ms. Prox then for docket call December 4th. Yes, Judge. At 9 a.m. So Ms. Prox will need to be in court on December 4th.
Okay.
All right.
Yes, sir.
You're free to go.
All right, thank you.
You're welcome. All right, Mr. Manning, who's next?
Judge, if I may have a couple minutes to discuss, we have I believe we're gonna have a hearing on Mr. Munn's. And I have a couple other cases I need to discuss
Okay,
final issues with clients.
just let me know when you're ready.
Thank you, Judge.
All right, I'll bring Mr. Quaid, come on up. Mr. Quaid, I'm gonna have you come on up here to this little blue square right in the front. Our camera's not working over there, so that way your attorney can see and hear you. You're good right there. Move over this way. Look, see that little square right there? Perfect, right there. All right, this is cause number CR 24-222, CR 24-223, State of Texas versus J. Stale Quaid. Mr. Thorson, Mr. Quaid is set for docket call today. Any announcements?
Your Honor, thank you for letting me up here by Zoom. Also, the announcement, I believe we have, Mr. Hartswell and I have discussed, basically passing this again. We're waiting on a decision from the Court of Criminal Appeals on the dog search issue. And there's also a co-defendant with a case pending. And I'm not sure the, position of that case for trial. We have made this announcement several times, and that kind of continues to be where we are. So, if possible, I guess I'd like to ask for a date. I mean, obviously, we want to keep tracking it, but if we can set it in November or December for another docket call, that'd be great.
That's correct, Your Honor. I just looked yesterday to see if I could find any kind of an update on the pending case. It's the case is styled Oregon v. State. I can't remember which county it's originally out of. But that case is still pending. There's no update or ETA on an opinion. I think we're about 5 or 6 months waiting for one.
It was a
That-
case that bears directly upon this search, Judge, and we've kind of talked about this before, and you're familiar with it?
Understand. Let him finish his.
And Your Honor, as Mr. Brand has mentioned, it very well could be dispositive here. So state would join in requesting that this case be set over for status, waiting on that case to come out.
All right, court grants the request and sets Mr. Quaid then for docket call on December 4th. And we'll carry it for status that day as well. So December 4th, at 9 AM. And I'm gonna have my staff have Mr. Quaid copy of it, and then he's gonna be free to go.
Thank you, Judge.
You're welcome. Thank you, Mr. Thorson. Good to see you.
Good to see you too.
We have any other counsel that's ready?
Judge, if I may, after speaking to the state, I think we're ready to reset one more case.
Right?
Mr. White, Martin White.
Mr. White, State of Texas versus Martin Lee White, CR 25-145, I'm sorry, 148, 149. Mr. White is set for docket call.
Judge, we received an offer recently on Mr. White's case. It was based on some evidence that after speaking to the state, I believe is going to change the offer. We'd ask for one additional docket call, make a final docket call.
State.
No objection, Your Honor.
All right, court will set Mr. White for docket call December 4th, 9 AM. Once he signs his notice of appearance, he's free to go.
Thank you, Judge.
All right, good morning. Can you see and hear me okay?
I can, Your Honor. Good morning. How are
Alright,
you?
I'm good. Remind me, is it, I can't always remember how to say your name. Is it Lucanen?
It is. Yep.
Okay. I have to give credit to my staff because she told me that's what it was and I looked at her like it wasn't.
Yeah,
All right,
it's a little confusing.
This is cause number CR 25-101, State versus Vincent Alford. Mr. Alford was set for pretrial today. My staff has indicated that based on your communications, that the defendant may be hospitalized or something of that nature.
Yes, Your Honor, that's my understanding as well. As I was waiting to come into the hearing, my staff emailed me that he's at Dallas Methodist. And apparently we're thinking it is a stroke. He has a prior stroke before, but that's the current situation. And my understanding is a nurse is going to be emailing us a letter indicating his status.
All right. And so the internet cut out a little bit during your announcement. We heard that he was at Dallas Methodist and the rest was kind of choppy up until you said a nurse was going to email a letter.
That's correct, Your Honor. It's our understanding that he possibly had a stroke. He's had strokes in the past, and so as soon as we get the letter, we will forward that to the court.
All right, court will reset Mr. Alford. My next setting would be in December 4th.
Okay.
Available that day?
Yeah, that will work.
All right, court will set Mr. Alford for additional pretrial December 4th. And then just go ahead and provide me that information as soon as possible
Most certainly.
on his hospitalization for today.
Yes.
All right. Thank you, ma'am. Have a great day.
Thank you. You too. Bye.
Who would you like first?
Could we call,
Yeah, Fontenot.
Mr. Strange?
Richard Thomas Strange, CR 25-104. Go ahead, Mr. White.
Your Honor, I provided Mr. Hernandez with some information on Mr. Strange that he requested. I'm sure, that he's still in the process of probably reviewing that. If they don't object, I think if we had about a 30-day reset for a final docket call, we'll be able to give the court a decision on what we're going to do.
State.
That's correct, Your Honor. I'd appreciate that. Thank you.
All right, court sets Mr. Strange for final docket call December 4th, 9 a.m. Mr. White, who else are you ready on?
Mr. Fontenot.
Mr. Fontenot. This is cause numbers CR 24-258, 2025-346, and 2025-425. All right, Mr. Fontenot is set for pretrial in his misdemeanor cases, I believe, and docket call on his felony case. Go ahead.
Your Honor, so I spoke with Mr. Hernandez on these cases. we're not gonna have any contested motions or anything on the misdemeanors. We're still trying to figure out if we got a restitution number, I think, and I believe Mr. Hernandez said that we talked about a possible resolution, but he believed needed to speak with the alleged victim on this. I don't think that they've been able to get that accomplished just yet. I think if we had the December 4th day for a final docket call, we can tell the court what we're gonna do on that date.
Mr. Hernandez?
That's correct, Your Honor. We would join in the request for the final docket call.
All right, court sets each case for final docket call December 4th at 9 a.m. Next,
Mr. Jimenez.
Gilberto Jimenez, CR 24-210 and 211. All right, I believe that we're waiting on a ruling from the Board of Criminal Appeals. Any update on that?
Yes, sir. I checked the CCA website. That case is still on submission. It was submitted May 7th. It has not, doesn't look like there's been any additional requirements from the court at this time, but just waiting to make a decision.
Any announcements from the state?
No, Your Honor.
All right, court will carry Mr. Jimenez for status on the ruling from the Court of Criminal Appeals December 4th. 9 a.m.
Mr. Mingus, Stu.
All right, court's calling case from the afternoon docket CR 24-143, State versus Obed Baru Mengistu.
If the court would recall on Mr. Mingistu, he was in Dallas County facing a number of charges. My understanding now is that he received a 20-year sentence to TDC. I made Mr. Hernandez aware of that. I'm sure he'll do his independent verification of it, and then we'll decide whether or not we need to bench him up here or how we're going to handle that.
Mr. Hernandez?
That's correct, Your Honor. It shouldn't take very long to confirm that. Case, the state would will provide the court with a motion to dismiss.
I have the TDC page website that Ms. Tabraham printed out. Shows that he was sentenced on June 27th, 2025 out of Dallas County, cause number F23-49227 to 20 years for trafficking of persons less than 18 for prostitution.
Based on that information, Your Honor, the state would make an oral motion to provide a written notice today.
Okay. All right, then the court grants the state's oral motion to dismiss. Case is dismissed. Thank you, Mr. White.
Thank you. And of course, when the court's ready to take up Mr. Treadway.
Do we have paperwork? I haven't seen any paperwork.
I have it all here, Your Honor.
Right, Mr. Treadway. All right, this is cause number CR 24-00008, State of Texas versus Jeremy Lynn Treadway. Court finds that Mr. Treadway was convicted by a jury on Friday. I'm sorry, I believe that was on Thursday, October 9th, 2025, and then was sentenced or was recommended a sentence of 10 years confinement in the Texas Department of Criminal Justice on Friday, October 10th, 2025. And on that same day, the jury recommended to the court that that 10-year confinement sentence be suspended and that Mr. Treadway be placed on 10 years. I'm sorry, that he be placed on community supervision. The court, after considering the evidence in the case, is ordering that Mr. Treadway be placed on 10 years community supervision for the second degree felony offense of indecency with a child by sexual contact as is required by law. The court has placed him under a program of terms and conditions for which he must comply, including sex offender registration as required by statute with sex offender conditions. The court this day is assessing a sentence at 10 years confinement in the Texas Department of Criminal Justice. That sentence is suspended and Mr. Treadway is placed on 10 years community supervision. Mr. White, did Mr. Treadway get a copy of Chapter 62 as required by statute?
He did, Your Honor.
All right. Court finds that Mr. Treadway has received a copy of Chapter 62, sex offender registration requirements, and has also submitted the supplemental admonishments for sex offender registration requirements to the court, in which Mr. Treadway is required to register for the remainder of his lifetime due to the conviction for the offense in this case. Mr. Treadway, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence.
Your Honor, my apologies. There was also a fine. I don't believe the court.
Oh, I'm sorry. You're right, Mr. Hernandez. The jury did recommend also, as part of the punishment, that Mr. Treadway be fined in the amount of $10,000. The court is imposing that sentence today. In addition, court costs of $290 and reimbursement fees of $115. I did have a question on the fine, Mr. Hernandez. Perhaps you can help me. I see that the fine imposed on page 3. I think it's page 3 of 5. It says on the judgment, it's really, I think page 2, but it says that the fine is separated between $9,900 and then $100 for the child abuse prevention fine. Is that fine? Does the statute provide that that fine can be broken down and such if it's returned by a jury, or if that's only on pleas?
I'm not entirely sure, Judge. I also saw that and I thought that may have just been the court's practice to do it that way. I can certainly inquire about it, but I thought that the fine itself was $10,000.
Let's look it up real quick. I don't have my code book. It's CCP 102.0186, CCP 102.0186. If it's allowable, then that's fine by the court. I just want to make sure that it's not only those cases that are plea bargains. Mr. White, while we are awaiting a review of that statute for the fine, have you counseled your client on his right to appeal? And does he understand the deadlines therein?
Yes, sir. I have prior to trial commencing, the state had prepared a notice of appeal in the event of a conviction. We sign that. And obviously, the court will fill out the rest of it. I've informed Mr. Treadway that if he wants to appeal the case, he needs to speak with another lawyer that specializes or that handles appeals. He's got some deadlines. I've explained those, but I'll do it here on the record. He's got 30 days to make a decision as to whether or not he's going to file a notice of appeal or file a motion for new trial. The operations of those two, the notice or the motion for new trial have an effect on other aspects of the appeal as to when records are due, et cetera. That would be something that the appellate lawyer would counsel him on. But I've told him that, you know, he needs to get on top of that, because if you don't take the necessary steps, you waive that right.
Okay. You understand those things, Mr. Treadway?
Yes, sir.
Okay, thank you.
Your Honor, if I may.
Yes, sir. please.
Pursuant to that code section, under A, a person convicted of an offense under, and obviously it's the applicable statute, shall pay a fine of $100 on a conviction of the offense. I don't know, there is no breakdown. That is a separate amount that would be designated to help fund programs to prevent child abuse. And it has its own section for it. So I don't know if the breakdown takes it out of the $10,000 fine. But there is no designation there.
Thank you. I think what I'll do then is we'll just take that $100 out of the 10,000.
Yes, sir.
We'll designate the general fine as 9,900 and the child abuse prevention fine as 100.
Thank you.
Any objections to that, Mr. White?
No, sir.
All right. Anything else from the state?
No, Your Honor. Thank you.
Anything else from the defense?
No, sir.
All right, Mr. Treadway, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Sergeant Martinez. After that, you'll meet with the probation officers. Mr. White, Mr. Hall, Mr. Hernandez, Council. Right, this is the sanctions court hearing in CR 20-291, State of Texas versus Kyle James Holland. All right, Mr. Holland, I see that you complied with your probation fee payment. You complied with your court collection fee payment. I'm gonna order you to come back on. Have you paid for this month or was that for last month? Have you paid in October?
Yes, sir. I paid 2 days ago.
Okay, good. All right, I'm gonna have you come back on December 4th. And we're gonna do 60 to probation, 170 to court collections, and that'll be for your November. Okay?
Yes, Your Honor.
All right, make sure you get that stuff turned in prior to the week of the court so that my records can be updated.
Yes, sir.
So December 4th, 60 to probation, 170 to court collections. All right, court's going to stand in recess, give the attorneys time to work. We'll resume shortly. This is cause number CR 25-100, State of Texas versus Jarek Chase Munns. Mr. Munns was ordered to be present in court today for docket call. Court finds that he was present earlier. The court in recess, allowing Mr. Manning time to speak with his clients. During that time, the court ordered the pretrial release officer, Mr. Todd West, to perform your release. Mr. West, if you're over here. Mr. West, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right. Did you administer a urinalysis test to Mr. Munns as directed by the court?
Yes, sir.
And what was the results of that
It's
test?
positive for methamphetamine.
And did Mr. Munns have any comment or make any admissions to using methamphetamine?
He did it. He did on the way out of the bathroom. He told his family that he tested hot for methamphetamine.
And were you present? Did you hear him say that yourself?
Yes, sir.
All right. Any questions, Mr. Manning?
Yes, Judge. So what you're saying, Mr. West, is Mr. Munns did not admit to methamphetamine use. He did not admit to ingestion or injection of methamphetamines. But what he was telling his family was that he was confirming what you had just told him, was that your test showed that he was positive. Is that correct? And he didn't sign an admission form. Is that correct? And he did not make any further statements saying that he had used or believed that he should test positive for methamphetamines.
He did. He did while in the bathroom. He said,
Okay, but is it your position that a urinalysis would detect meth use from a month ago?
and we're seeing it. So
If you can answer my question, is it your position that meth use from a month ago would be tested and show up on a urinalysis? And so you were stating, in response to my last question, you were stating that the urinalysis is being sent off. Why is that? And is it possible that the urinalysis test could have been incorrect for this type of substance?
not under my understanding.
But is it possible? Okay, and that's why you sent it off for scientific testing. Is that correct? Okay, no further questions.
State, any questions?
Just to briefly summarize, so Mr. Munns appeared today and you saw him here in court today
Yes.
and performed a urinalysis. And during that urinalysis, he told you that he had used a month prior. So there's one admission, but no admission about necessarily today's positive UA. Was Mr. Munns on conditions of probation approximately a month ago when when the admission is regarding? He was, okay. No further questions, Your Honor.
Mr. Manning,
Nothing further.
thank you, Mr. West. Mr. Nicholas, you'll come forward. Mr. Nicholas, you are the owner of Roy Brockway Bail Bonds, correct? Yes, sir. And you are the bondsman for Mr. Jarek Chase Munns, is that correct? Yes, sir. Is it my understanding that upon Mr. Munns learning that he had tested positive for methamphetamine, that he exited the courthouse, which later resulted in a conversation between you and he? Yes, sir. And can you tell the court about your conversation with Mr. Munns?
Yes, sir. I saw that he had left the building. His attorney had come out looking for him. He had assisted his mother in the elevator. And at the time, I assumed that he was, just helping his mother downstairs. I very soon learned that he had tested positive for meth, and that I assumed that he was not only helping his mother down the stairs, but actually trying to leave. So I immediately went downstairs, followed his mother across the street to where the car was parked. He was in the driver's seat, so I walked up to the vehicle and, saw that it was me. I immediately had a kind of a defeated look on his face, but he rolled the window down and I instructed him that, He wasn't ready to go. He said that the pretrial release officer said he was good to go. But I told him that he hadn't had his hearing yet. I need to, come back because his lawyer was looking for him. At which point, he more or less put the car in drive, started to take off. I was hanging on to the handle, but I came back and advised, about what happened.
Thank you, Mr. Nichols.
Yes, sir.
State, any questions of Mr. Nichols?
Nothing from the state, Your Honor.
Mr. Manning, any questions?
No questions.
Thank you, Mr. Nichols. Appreciate
Thank
it. All right, court is going to find that Jarrett Chase Munns bond is insufficient in the amount of $100,000. The court today is ordering bail to be set at $500,000 and for violations of the court's pretrial release conditions and for failing to appear in court as ordered. Court is going to order the clerk to issue a capias for his arrest. So I'm pretty confident that Mr. Munns is going to be back in custody shortly. He can enjoy his last day or so of freedom, and we'll see him back on docket call December 4th at 1:30. If he makes bail, then it'll be at 9 a.m.
Yes, Judge. My understanding is, and from talking to the state and to others, that Mr. Munns has pending charges in the federal system. If he is picked up by them, I don't have a way to know that. Is there a way the state or the court could let me know is if he is incarcerated federally?
State.
Your Honor, when the 12-4 docket comes around, between state and Mr. Manning, we're usually in communication prior to. I'm sure one of us will remind the other that we need to check into that and see if we can determine whether Mr. Munns is in custody at that time.
I'd like to be notified if someone's going to take possession of him, seeing that I've got a state case against him and I've ordered that he be incarcerated. So hopefully the federal authorities would consult this court before they just take his body. So, but as soon as I know something, you'll know something. Take it, Judge. You as well, Mr. Hartwell.
Thank you, sir.
All right, Mr. Manning, you have any other clients that are ready?
Yes, Judge. Sorry. What was that last name? Did I have it wrong?
Clients that are ready.
Yes, Judge. Mr. McLeod.
Shane Albert McLeod, CR 25-98. All right, Mr. McLeod is set for docket call.
Yes, Judge. Mr. McLeod and I met last Friday to discuss his case as well as the plea offer that was extended in his case. At that time, we crafted a counter proposal that I presented to the DA's office, and we request an additional docket call for time for them to consider that.
No objection, Your Honor.
All right, court will grant a final docket call December 4th. 9 a.m.
Thank you, Judge. Next, ready on Ms. McFerrin.
Linda Mabry McFerrin. CR 25-151. Ms. McFerrin is set for docket call, I believe. Does your client need to have a seat?
Good to sit down.
No, I'm fine.
Okay,
Thank you.
go ahead, Mr. Manning.
Judge, Ms. McFerrin and I met about her discovery, I believe 2, maybe 3 times, as well as discussed her discovery on the phone today. Sorry, on the phone previously and discussed it today. She has received an offer from the state, which we've also discussed, and she has. There's been information provided to the state that may be mitigating or exculpatory from the complaining witness. She's asking for an additional docket call so that she can review the discovery one more time, as well as the state have time to review the statement made by the complaining witness.
Any objections from the state?
No objection, Your Honor.
All right, court will grant the defendant's request for an additional docket call. Court says docket call December 4th.
You should be excused.
Please excuse.
Thank you, Judge.
All right, I believe that does conclude the court's morning docket. Court will stand in recess till 1:30 for the court's afternoon docket from the Van Zandt County Jail. Court's in recess.